My Lord, just three brief points in, I hope, no more than 5 minutes. One is that with many thanks to Ms Dakin and also the team at Matrix, I think you have now, by Ms Davidson, been emailed the legislation.
Thank you.
The breakdown that you requested. I wanted to just do one reference that goes to a number of points which I don't think I took you to before, which is Mr Justice J again. Can I just show you these paragraphs 42 and 44, which are at pages 213 of the supplementary bundle.
213.
213 of the supplementary bundle, which is at paragraph 42. My Lord, this is just to alert you, and I adopt this analysis, which is when it is being said that Parliament must be taken to have had in mind that Section 5 existed, and it must be
Which
taken.
paragraph?
Paragraph 42.
Yeah.
Of Mr Justice J in the Commission's determination at first instance. This point is that what he is saying is not accepting Mr Giovanetti's submission based on the proposition that Parliament is deemed to legislate against the backdrop of the existing law, which includes Rule 11A, but also, for our narrow purposes, Section 5 of the Act, as amended by Section 6A, or supplemented by Section 6A. He says this: in our view, the whole point of the new provisions was to bring into scope an entirely new and different jurisdiction. That jurisdiction was intended to be based on the application of judicial review principles to these review proceedings from cradle to grave. Parliament cannot have overlooked the costs payable in judicial review proceedings. So what he is saying there is that Parliament had in mind the comparative with judicial review, not what was going on in relation to appeals and Section 5, etc. And the reason why I just flagged that is because now I have taken you through, partly by reference to my skeleton and partly by reference to Lord Taylor in Hansard this morning, all of those references, to the extent that there is any discussion, they are talking about judicial review, they are not talking about appeals. And I say
They're not talking about
appeals. Well, the comparative they have in mind, what they are striving to replicate, is not what is happening in appeals, but what has been happening in judicial review. And that's why you also then see at paragraph 44, we also cannot accept Ms Giovanetti's point that Parliament in 2013 must be deemed to have recalled the wording of Rule 11A. That is something of a long shot in the context of a recondite provision which has nothing to do with normal. So I adopt that in relation to Rule 11A. That is what Parliament, to the extent it was thinking about anything at all, it was thinking about judicial review, not about appeals. So I do say that one should strive in looking for the right construction.
I mean, how do you reach that conclusion? I mean, it's not an either or. I mean, you know, they may have had lots of things in mind. They may have had Section 5 in mind. They may have had previous regime under judicial review. They may have had the regime under appeals, which they imposed by Section 6A. I mean, what are we doing saying this is the only thing they had in mind?
That is what they're trying to replicate. I say that that's what it...
That's your submission.
That's my submission, based on...
But why? What's the foundation?
The dual reference to judicial review in the sections themselves, the explanatory notice referred to judicial reviews, and the Hansard references that refer to judicial reviews. You are hearing a judicial... I've put you in my skeleton. Okay. You are hearing a judicial review in SIAC.
Does the SIAC judgment you've just been showing us deal with the point that Section 6 capital A is there and says what it says, because it seems to equate appeals and reviews?
No, it doesn't deal with that.
Right,
but I'm saying that is insufficient, given that is insufficient to displace the bigger steer that I say from where these cases have been. And I do say all of these point in the same direction. Contents of the Act, contents of Hansard, explanatory notes, Ignaua, all the people who are involved talking about judicial review, trying to replicate that. And the only other point, my lords, just before I sit down, the answer to my lord, to the extent I have an answer to my Lord Justice Singh's point about McCaffrey. My lord, I am slightly struggling to answer that question because I don't know how the arguments were put on the particular point about principles, nor the foundation for those arguments. But my understanding is the comparison is not precisely the same as it is here. Here we have judicial reviews, transfer across,
yes.
They're now SIAC.
Yes.
It's a bit messier.
No, you're quite right to make that point. the only point that might be made is that there are some cases which otherwise would be within the jurisdiction of the administrative court, which are placed by primary legislation within the exclusive jurisdiction of the IPT.
Yes.
And so to that extent, it could be said that they have been, those cases which would otherwise be in a full costs regime, in fact have to be dealt with in a no costs regime. That's the only point.
I accept that. My lords, unless I can assist at this stage.
Thank you very much. Yes, Mr.
Thank you, my lords. So I'll follow the same course as Mr. Armstrong, if I may. I don't propose to address you on standing. You have our skeleton argument. It was raised really because it was mentioned by Lady Justice Lang in the grant of permission. I'll address you first of all on the interpretation of section 2D, sections 2D, 3 and 4. And then on Article 14. So, 2D, 3 and 4 are addressed in our skeleton argument, which you've got at tab 7 of the core bundle, starting at page 50.
Yep.
And this section of the analysis starts at page 55, paragraph 22. The Divisional Court considered 2D3 and 2D4 together. We say it's right to do so. That's very sensible and entirely consistent with all the guidance about statutory construction, which is you consider the language in context, and in particular in context of language of the surrounding subsections of a section. So by 2D3, you've heard this repeatedly this morning, in determining whether the decision should be set aside, the Commission must apply the principles to be applied in judicial review proceedings. You've got the provision tab 2 of the authorities bundle, the foot of paragraph page 24. And then by 4, if the Commission decides the decision should be set aside, it may make any such order or give any such relief as may be made or given in judicial review proceedings. And I accept, obviously, that 2D4 at first blush looks as if it's very wide indeed. But in our submission, the Divisional Court was right to find that when you examined it a little bit more closely in context, there are a number of powerful indicators which looked at cumulatively point to the conclusion that what Parliament had in mind was the orders and relief that are specific to judicial review.
What does that mean?
Well, you've got at tab 1 provisions of the Senior Courts Act, and we say in short what it means is the orders and relief covered by section 31 of the SCA. So tab 1 of the authorities bundle, page 11.
Well, why doesn't it refer to section 31?
Well, it's doing so, we say, by referring to the orders and relief available on judicial review.
I mean, I simply don't understand even the argument that the words "it may make any such order as may be made in judicial review proceedings" doesn't mean what it says.
No. Well, if I can try and develop my argument,
Yes,
I'll explain
I
why.
need, but how can it be limited by something like section 31, which is not mentioned, when it is so clear? That's what I'm asking.
Yeah. I'm not suggesting that section 31 limits it. What I'm suggesting is that what Parliament intended to do was to transfer across judicial review proceedings from one jurisdiction into another jurisdiction, i.e. from the administrative court into SIAC. And it wanted SIAC to be able to grant the same substantive remedies as the administrative court would be able to grant: quashing orders, declaratory orders, mandatory orders, and that in deciding whether or not to grant those orders, it would apply the same principles as the administrative court would be applying. What it wasn't intending to do was to set up within SIAC a narrow and limited exception to SIAC ordinary procedural and ancillary powers applicable only to this new category of review cases. So it was concerned with specific judicial review remedies. And I appreciate that argument might not be particularly attractive to the court if we were only looking at those words, the narrow words of section 2D4. And on their face, and as a number of judges have observed, on their face they seem very wide indeed. But as soon as you start scratching away a little bit to see what the consequences would be, it becomes more and more difficult to support an argument that what Parliament was intending to do was set up a separate cost regime.
Well, it's not a separate cost regime.
Well, it would be a different cost regime in SIAC to the cost regime otherwise applicable, namely that costs are to be dealt with by rules made by the Lord Chancellor.
It's actually also a different cost regime from the one that did apply in the administrative court.
Absolutely, it is. Yes, entirely different. It's a very narrow one-way costs sort of power that applies only if the decision's set aside, which is quite different to what would have applied in judicial review.
I mean, of course that's true, but how do you get around words that are absolutely crystal clear? I mean, this is the, show me a case where words that are absolutely crystal clear because of the adverse consequences have been construed to mean something completely different with a completely nuanced addition, qualification that nowhere appears. Yeah. That's what I need. I need to see one example of just ignoring the words and making it mean what you'd like it to mean.
No.
I mean, these words are not ambiguous.
No. Well, I hear what my Lord says, but in my respectful submission, they are in context.
Okay, is there a case that does that?
Well, there are cases, well, not with this language. I mean,
No, but a clear language that's simply ignored,
well,
as because it's convenient to do so. I mean, that's what the divisional court. We need to look at the divisional court's reasoning, don't we, to see if it can be supported. Because you support it.
I do support the
every last word of it.
Could I take you through my submissions and then go to the divisional court's judgment?
Yeah.
So my first point, paragraph 28, skeleton argument of my skeleton. Sorry, I'm going to
Yeah.
So the powers specific to judicial review are in section 31 of the Senior Courts Act, which I've just taken you to. The wider powers of the High Court are, as the court will be aware, in section 51, and I suppose Parliament could have said, if the Commission decides that the decision should be set aside, it may make any such order or give any such relief as may be made by the High Court. I mean, it didn't, and it wasn't on any analysis. Intending that there should be a costs order made in favour of the Secretary of State and against an applicant for review. Because it's not just looking at subsection 4 together with subsection 3, it's looking at subsection 4 as a whole. And it's very curious that it applies, if it is intended to confer a cost power, subsection 4 applies only if the Commission decides that the decision should be set aside.
Well, why is it curious?
Because it doesn't give, it could say, on considering an application for review, the Commission may make any such order or give any such relief, and that would import a two-way.
Well, there's 2 points you're making. One is that it could be two-way, but also it could be in favour of the applicant. For example, if there's been costs thrown away because the Secretary of State isn't ready for a hearing and it all has to be adjourned at the last minute. So you haven't reached the stage of the SIAC setting aside anything.
Precisely.
But your point is that these sorts of cost issues are simply not addressed.
No, it's extremely limited, with no apparent reason for it to be extremely limited, to a power that arises only if the Commission decides that the decision should be set aside.
Well, Mr. Giovanetti, can I ask you this? Do you accept that if the Lord Chancellor were to make rules about costs, that he would have the vires to include all sorts of situations, including interim stages, and that it could be against either party?
I do completely accept that.
Of course.
Which takes me into my sort of second point, really, that Parliament must be taken to know what the scheme is that it's legislating about. And it was legislating against the backcloth of a scheme under which, as this court's held in C7, power to make provision about costs is conferred upon the Lord Chancellor Indeed, the point's sort of slightly stronger than that, because it wasn't just that that was the pre-existing scheme. Parliament expressly, by section 6A, by introducing section 6A, extended that to cover reviews. And that was my third point, paragraph 30 of the skeleton argument.
But you accept the words order, such order as may be made given in judicial review must include cost orders. I mean, it's a matter of ordinary meaning.
If it was just those words in
Yeah,
isolation, without the beginning words of the section and without the context of the sections around them, of course I accept that a costs order can ordinarily be made in judicial review proceedings. But I don't accept that Parliament was intending to cover costs orders by this subsection. I don't think it had that in mind at all. It was intending to confer the power to determine judicial reviews in this particular context with national security cases on SIAC.
Doesn't that rather dilute the effect of subsection 4, saying it may make any such order or give any such relief. It could have just said it may give any such relief as may be made or given in JR proceedings. And relief seems to me to be an echo of Senior Courts Act section 31, which
Yes.
you referred us to, which does away with the old terminology of certiorari and mandamus and what have you, and says relief can be a quashing order, a mandatory order, whatever the other one was, and then by subsection 2 also an injunction declaration. So that's relief. But order seems to me anyway to be wider, and it can do other things which are not substantive relief.
I wonder if this might be a helpful point at which to turn to McCaffrey.
Just before you do that,
Yeah, sure.
since my lord has raised section 31, it may be helpful to look at subsection 5 of section 31, which I think is what the divisional court had in mind in paragraph 64 of its judgment. Because the structure of 31 is quite interesting. If we have it page 11 of the bundle of authorities, as my lord says, subsection 1 says an application to the High Court for one or more of the following forms of relief.
Yes.
Right? So relief is then set out in the terms that my lord has outlined. But if we scroll down to subsection 5, there's an important additional power to make an order of a kind that wouldn't necessarily be inherent in simply making a quashing order,
No.
which
Yes.
is in particular paragraph A, remit the matter to the ... authority which made the decision, with a direction to reconsider the matter and reach a decision in accordance with the findings of the High Court. And I think that's what the divisional court had in mind at paragraph 64. So they took the view, rightly or wrongly,
Yes.
that it is possible to give a sensible construction to that alternative phraseology of order as compared with relief in the context of section 31.
Yes. I completely agree with and adopt that. No, I'm not going to make the point better by trying to repeat it. I'll make it worse. But yes, that's exactly my submission.
I mean, that all makes perfect sense, except the word order is not. It doesn't say order under section 31(5), and the word order is very broad.
I obviously accept that.
Yeah,
That's
I
quite-
mean, it's a, I mean, you know, it's maybe we need to look at, you know, Benyon and other cases that deal with situations where Parliament has obviously made a mistake, because it, to me anyway, it may not be my lords the same, but to me it's absolutely obvious here that what's happened is Parliament has simply not thought about this properly, and there hasn't been adequate scrutiny, and nobody has said, hang on, section 5, which was there before, envisaged a costs regime being made. No cost regime is being made, and this is a very broad provision which might be said to include anything. So what do you do in that situation? I mean, you know, I'm my heart is with you that says you're right, it's obviously not intended to achieve this, but I'm rather reluctant to drive occasion horses through statutory language when it's clear. And you know, my understanding of construing ambiguities is one thing, but it's not the same where it's absolutely clear. And order means order. Now, okay, so you can say such order in the context of judicial review proceedings directs you to section 31. I think that's what the Div Court said. Sort of does. But it might direct you to another provision that my lord will tell us the number of about costs in judicial review.
Well, it's just a general one.
General one in 51.
General one.
There's also 29, isn't it?
Well, 29 is about mandatory orders and so on. But section 31 refers to relief, by, I think it cross-refers to section 20. Not sure we get much out of section 29, but it may be worth just...
I'm sorry, I don't think we've got section
We haven't,
29.
no. I've
I'm
looked
sure we can provide it. But we thought that sections 31 and 51 were the key ones. One being the sort of specific judicial review, remedies and orders, which is, what we say in context, that's what Parliament intended to do, give SIAC the power to make orders and grant relief that would be within section 31, whereas section 51 is the cost powers of the High Court, and that's what we say Parliament did not have in mind. It would have been needing to confer on SIAC, it would have needed to intend to confer on SIAC directly, a cost power that SIAC did not have directly in primary legislation.
And I suppose you say the beginning part of 3 and 4 is the clue that it's really not talking about ancillary structure, because you don't really ever make provisions about costs in the context just of a particular form of order.
Yes, I would say that. And in particular, it would be creating such a unique and unusual cost power in SIAC that if it was
unique, I mean, one-way cost shifting is not unique, but what's unique about it is that we've never really heard of a cost order that only is specifically dedicated to a particular order being made and not other orders by the same tribunal.
No, and when you look at sort of one-way costs, there is an entire regime governing them. Where the point that was made in McCaffrey, and I think it's probably my strongest point, that if Parliament was intending to do that, you would expect it to do so expressly and explicitly.
Should we have a look at McCaffrey?
Yeah. So,
the RIPA background is different, but
it is tab 29.
Do you have a page number?
Yes, I'll give it to you in 1 second.
So which paragraph?
It starts at page 699, and then maybe the first paragraph it's helpful to look at. We've looked at it briefly already. At 705 is the principles provision in section 67 of RIPA. So it's section 67(2), which is very similar to 2D3. And then the provision that was identified by the applicants as giving rise to a costs power with 7, which you've got towards the end of that page.
Sub 7.
Sorry, could you do it on paragraphs, Mr. Vanetti?
Oh, I'm sorry.
Being an old-fashioned sort, I'm following this in the All England.
It's paragraph 28, subparagraph 7. Beginning subject to any provision.
Yes.
Subject to any provision made by rules under section 69, the tribunal on determining any proceedings, complaint or reference shall have power to make any such award of compensation or other order as they think fit.
Yeah. And then specific orders are listed.
Yes.
Which are a bit like judicial review orders to some extent, like an order quashing.
Yeah.
And so on.
Yes.
So you say, not on all fours, at the same point.
Yes, I do. And this was decided after SIAC's decision in our case, but before the Divisional Court's decision. And Mr. Jaffe, who was appearing for the applicants, at paragraph 63, made the submission, it's the last sentence, starting 3 lines up from the end, the line beginning deliberately wide meaning, Next sentence. Indeed, he submits, the language of section 67.7 is broader than the equivalent language in section 2D4 of the 1997 Act, which was held to be sufficiently broad in FGF to include the power to award costs. If we pick up the reasoning at the bottom of that page, it's paragraph 68. We've reached the conclusion this tribunal does not have the power to make an order for costs for the following reasons. 69, no express reference to costs orders.
But there was a stronger case there, actually, because there were references only to substantive remedies.
I'm so sorry, I didn't quite...
There was only reference to substantive remedies in the subsections following the any order part.
In the listed examples, that's right. But we'd say that's the equivalent to the judicial review orders that are referred to. We say by, obviously...
Well, it's not in the Act, though, is it? It's got to be done by reference. I mean, it seems to me this is a stronger case, but I get the analogy.
Yeah. Then at paragraph 71, and I think that's the point that was made by the IPT at 70, that list of orders gives the context. But at 71, the effect of the submission being that there's a power to award costs only against one side in litigation in this tribunal, that is against respondent. Although it's possible that's what Parliament intended, it would be surprising that that had not been spelt out clearly in the terms of the governing legislation.
I think what Mr. Armstrong says in response to that is in the context we're dealing with, actually it has been spelt out by Parliament clearly because of the opening words, if SIAC sets aside the decision. So it can only apply in one situation. If it was intending to create a cost power in that context, exactly.
You could expect it to say specifically that SIAC has power to award costs.
Exactly. That's your fundamental point.
It is my fundamental point.
That nowhere in the express language in the provision we're construing does Parliament actually use the word costs. At all.
Yes.
Whereas what you say, and this is where you're going to end up, I think, is that there is a very natural place where Parliament has catered for the possibility of creating a costs regime, namely rules made under Section 5.
Yeah, absolutely. Yes. And then at 74 and 75, I'm not proposing to read them out, but there's the point about legal certainty and how should the cost power be exercised.
Yes. Can I just make one observation, if you don't mind, about paragraph 76? I think the divisional court may have slightly misunderstood our judgment, I'm afraid. I don't think it matters, ultimately. We were making the point there that the tribunal is not institutionally well equipped to engage in setting up a cost regime. But that's in the light of the first sentence of 76, which is that if there's to be legislative change, that would be made after there'd been the opportunity for public consultation. I think somebody somewhere seems to have misunderstood what we were saying as suggesting that because the tribunal doesn't have a sort of costs assessment office, that it doesn't have the mechanics to do it.
No.
That's not the point we were making.
No, that was not the point we were making, and if it was misunderstood, I'm sure it's my fault for not being clearer in my submissions. But it's deciding the principles that are going to be applicable on costs. So is it, for example, as it is in the tribunal, upper tribunal immigration, a reasonableness cost jurisdiction, or the first tier tribunal, that costs are awarded only where there's been unreasonable conduct? Is it costs follow the event? And it would seem that it would be that costs follow the event, but only in one way, looking at the primary legislative provision, which is very unusual, and one would expect that to be addressed specifically. There's nothing in Hansard to demonstrate that Parliament had that in mind, that it was considering conferring a cost power on SIAC and a one-way cost power, only to be a power that would only come into existence if SIAC determined the appeal by setting aside the decision on review.
Yes, it would be unusual, but then those cases involving closed material are unusual in many ways, and there is asymmetry of information and so on.
I'm not saying it would have been irrational for Parliament to do that. I'm just saying you would expect it to do so expressly, for it to be apparent on the face of the legislation. And that's a really strong indicator, we say, that it was not what it thought it was doing, it's not what it intended to do. At paragraph 34 of our skeleton, we point to the language that Parliament has used when it's creating or conferring a cost power on a tribunal. I'm not going to take you to it, but you have the TCEA 2007 at tab 4 of the authorities bundle. And it's worth looking at section 29. We don't need to turn it up now for my purposes, but it's worth looking at that as an example of the sort of way that Parliament expresses itself when it does intend to confer a cost power.
Mr. Giovanetti, does section 29 govern what happens about costs in judicial review proceedings when they're heard in the upper tribunal?
No, it doesn't.
No.
That's the usual familiar administrative court approach.
I see.
But
I think that's one of the core submissions Mr. Armstrong makes against you, is that here what's happened is that proceedings which could and in some cases were brought in the administrative court have been compulsorily transferred to another forum and by a side wind a radical change has been made to the costs regime.
there's only a very small part of the picture because, of course, as one of the key reasons for creating this jurisdiction in SIAC and for providing for transfer is the Carnduff principle. So in the administrative
Is which
court,
principle?
the Carnduff principle, Carnduff and Rock, that if the court is in a position where it cannot properly determine proceedings, for example, because material can't be looked at for PII reasons, the appropriate course isn't to grant or allow a claim for judicial review. It's to determine that it's a claim that cannot properly be determined and to either stay it or strike it out. So there was a period where claims where the decision was based on national security sensitive material couldn't be determined by the administrative court for that reason. And of course, transferring proceedings into SIAC means, on our analysis, where there's no cost power if the ordinary cost position applies. I was going to make the submission under Article 14, but I'll make it now. There are advantages to an applicant. Not only that the applicant is not liable or is not at risk of being liable for the Secretary of State's costs, which, as my Lord Justice Singh observed this morning, can be quite a deterrent to people who are considering bringing proceedings, but by doing so they may be exposing themselves to a substantial cost risk. But also, of course, in SIAC, and it's slightly different in the IPT, but in SIAC, the applicant for review is entitled to the assistance of special advocates, always one, often two. And they will be advancing the applicant's interests on the closed material. That's their task.
But, I mean, the point that is made on Article 14 against you is that it has a serious access to justice problem. People can't actually get lawyers to act for them in a no-cost regime.
Well, that's what's said. Can I just finish making the point, which is that not only do they have services of a special advocate, the assistance of a special advocate, advancing their case on the closed material, which is generally the substantial underpinning material. That's why it's gone into SIAC. But however affluent the applicant is, they are not liable for the costs of the special advocate, win or lose. So that's provided by the state. It is just a different system, completely. Two further points we make at paragraphs 35 and 36 of our skeleton argument. There wasn't proposing to expand upon orally. Can I just adopt those? There's nothing really I want to add to that. So unless you had any more questions on the statutory construction point, I wonder if this would be a convenient moment for me to turn to Article 14. Sorry, could I just turn my back for a moment? Mr. Evans very helpfully draws my attention to the fact that the power of the upper tribunal to award costs in judicial review proceedings is governed by Rule 10 of the Tribunal Procedure Upper Tribunal Rules. You don't have them in the bundle, but we can certainly provide a copy. We do have it in the bundle.
Tab 7.
Thank you. Tab 71.
Page 71.
Oh, sorry, page 71.
What's the net effect? If say 15 years ago I could have brought a JR case, as you know, many immigration JRs were again compulsorily transferred
Yes.
to the upper tribunal about 10, 15 years ago.
Yes.
But if previously I had been able to bring such an immigration JR in the admin court and I was subject to the full costs regime in Part 44, what would happen today? Do I have the same costs regime or do I have a limited costs regime in the upper tribunal?
It's the same cost
The same, yeah.
regime.
That's what I
It's
thought.
not an unreasonable conduct.
Yes, exactly.
No. So it's subsection 3. Sorry, Rule 10 sub Rule 3.
And it's A and D.
Beg your pardon?
It's A and D.
A and D. Thank you.
A and B, there's no B.
D.
D.
The general cost power in JR, otherwise unreasonable conduct.
Sorry, the general power in JR costs applies in the upper tribunal.
So you really only have one point, if I may say so, and that is that it must be construed as limited because there is no possible justification externally to the words, the broad words used in 2D4 for such a provision to come out of the blue when there's a proper regime in 6, when it's perfectly clear that there's no cost regime for appeals. 6A applies the same provisions as appeals to reviews, and it's a completely aberrant one-way cost shifting, which is unique really and unheard of, and it's an obvious mistake which the court is not required to, it must adopt a purposive construction.
Yes. I'm not sure I'd put it on the basis it's an obvious mistake, but it's an infelicity of language, because it's quite apparent that if you just read certainly the second half of 2D4 on its own, the language used is wide enough, and it has on numerous occasions led people to conclude, oh, that's very wide, that must surely include a cost power. And you have to, yes, look at the first half of 2D4, then look at 2D3, then look at the context to see that it cannot be what Parliament intended.
Yeah, it's a very weird situation. It's an unusual situation, which is why you can't point me to another case where such a thing has happened.
No, I can't think of a case that's directly comparable
And
to
if
this.
you can't, there probably isn't one.
Well, I certainly wouldn't say that.
Yeah, but you must have thought about it a little before, Miss.
Well, yes. The case that we thought was the closest was McCaffrey.
Mm. Well, McCaffrey is, yes, of course it's very close. It's the same thing, really. But,
Yeah.
And that appealed to my lord.
And not just my lord, I mean,
No, the other
not
four.
just my lord, but in addition, it was a very weighty panel.
Yeah.
And of course, notably, it included Mr. Justice Chamberlain, as he then was. I don't know if he still is for the moment, or I think he's already joined my lord. But who's somebody upon whom a learned friend places weight, that in a costs application in an appeal case in C7 at first instance, thought the meaning of 2D4 was clear, quite understandably. But on a deeper analysis of very similar wording in McCaffrey, he reached a different conclusion, as did the entirety of the panel.
I think.
Sorry.
I was just going to ask, do you happen to know whether McCaffrey is going any further?
I've not heard that it is. I'm sure we can make inquiries and let you know. We certainly haven't heard it was going any further last time I asked.
How recently is McCaffrey?
It was about a year ago.
Oh, I see. Probably not. I think we'd have heard it by now, wouldn't we?
Well, it wouldn't.
Oh, it doesn't come to us.
It wouldn't come to us.
It might be JR.
April 2025.
Even though it's a 5-judge panel of great distinction, the next stop would be divisional court, presumably.
Perhaps you could confirm that.
We will, yes.
Okay, Article 14.
Article 14. So, picking up our skeleton, page 60 of the core bundle, tab 7, paragraph 39. Appellants obviously have not been seeking a declaration of incompatibility. What they're saying is, in their Article 14 argument, that 2D, 3 and 4 must be read and given effect to in a way which is compatible with convention rights.
Well, I think they have explained how it's incompatible with Article 14 to be subject to the Lord Chancellor's rule-making power when the Lord Chancellor has not exercised that power.
No. But Parliament have the effect of the primary legislation is not to prevent the Lord Chancellor exercising that power.
True.
You can't have a provision that goes in and out of compatibility depending on what happens. If the Lord Chancellor has exercised his rule-making power 2 days after the legislation was given royal assent and had created a cost regime that covered appeals and reviews, it could not be argued that this provision was incompatible with the Convention, incompatible with Article 14. And the compatibility of a provision of primary legislation cannot be dependent upon the enactment of subordinate legislation. It may be there could be a challenge brought against the Lord Chancellor for failing to exercise his powers.
Well, what about the unison situation, where fees are made by statutory instrument, not primary legislation? Surely you can have a situation of a breach of Article 14 brought about by a mixture of primary and secondary legislation, in theory.
I don't think in unison, I have to check, and maybe I can do that and give you a note if I'm wrong, but I don't think in unison the primary legislation was, it was the actual increase in the fees that was incompatible, not the power to increase.
Well, it was held on domestic principles of construction to be ultra vires, because it all turned on fundamental rights in the common law. I may be wrong, but I don't recall it being an Article 14 case.
I don't think it was. It was access to justice.
Yeah, and not even not argued under Article 6. It was argued, in a sense, the Human Rights Act is unnecessary and irrelevant to unison. That unison would have been decided that way in the mid-1990s.
Yes.
I was only using it as a factual example.
No, I understand. Yeah.
But
I mean, do you say that's a complete knockout point?
I do. It's a fundamental flaw. It's in the entire premise of the Article 14 argument.
Because
it can't be incompatible with Article 14 for Parliament to confer a rule-making power and leave the question of costs to the Lord Chancellor, and that's what the primary legislation does on our analysis. It's not prohibiting the award of costs, it's not excluding the award of costs. It's simply saying that's a matter for the Lord Chancellor.
But what if this case went to Strasbourg? They wouldn't be interested in which particular organ of the state has arrived at the result. They would just want to know, has the state acted incompatibly with Article 14? And would they say yes?
Oh, I don't know. I don't think they would say yes for the other reasons I give. But you're absolutely right. The starting point is different in Strasbourg because they're looking at the UK as a whole. But here we're concerned with the compatibility of the primary legislation on this argument. So that's my first point, and I say I don't need to go further than that. It cannot be incompatible with Article 14 for Parliament to provide that SIAC's cost regime is a matter for the Lord Chancellor's rule-making power. The rest of my submissions on this are unnecessary if I'm right on that first fundamental point. So assuming that against me for the moment, ambit. It's right that cases turning on ambit are few and far between, and it's right that ambit is a large and expansive term. That doesn't mean you can just ignore it and tear it up. As we see by the cases that my learned friend took you to, the courts have considered ambit where it's necessary to consider ambit. I don't think Mr. Armstrong pursues his Article 8 ambit argument. He certainly didn't in oral submissions. Insofar as he does, I just simply rely on paragraphs 41, 1 and 2, little Roman 1, little Roman 2 of our skeleton argument.
A1P1 he relies on.
A1P1 was the central focus of his.
I do maintain it. for the reasons set out in the skeleton by reference to Johnson. But I don't at the moment represent FGF, who's the only person affected by it. That's why I focus, because H7 and H15 can only rely on A1P1 because they don't have article 8 implications.
Yeah.
So, positive modality, A1P1. I know the court will know what A1P1 provides, but it's quite helpfully set out in the Musa Tarhan case that the learned friend relies on at tab 32. Page 771, paragraph 56. Every natural or legal person is entitled to the peaceful enjoyment of his possessions. No one shall be deprived of his possessions except in the public interest, etc. Positive modality principle applies. I don't think this is contentious. Where the state confers a benefit the provision of the convention doesn't necessarily need to give you a right to that. But if it's within the ambit and the state confers it on one cohort, it can't do so in a manner that's discriminatory and offends against Article 14.
Yes.
And Mr. Armstrong relies on the AA case, which you've got at tab 24 of the authorities bundle.
I mean, can you just tell me your answer before you go to the cases? What's your answer to his point? There must be cohorts of people who don't have to come to SIAC and have the benefit of a cost regime and can get access to justice, who are in exactly the same position, save that they're not required to go to SIAC.
But looking firstly at the ambit point, which is what I'm focused on at the moment.
I'm talking about the ambit.
Sorry.
Yeah.
So I'm saying that the possibility of making an application for costs is not a possession, and it's nowhere near being a possession for the purposes of Article 1, Protocol 1. We don't need to turn it up at the case of AA, which Mr. Armstrong relies on, it's paragraph 41.3, little Roman 3 of our skeleton argument, started off by observing that a claim for damages, which is what it was concerned with.
Which case?
Oh, AA in the Secretary of State for Education.
Yes. Yeah.
Tab 24.
Yeah.
And this is the case that my learned friend started with on his positive modality approach. Key paragraph is, remember that it's the judgment of Mr. Justice Singh. And the key part of his reasoning is at paragraph 57. And he explains at 57 why he feels that the case is, or why he concludes that the case is a positive modality case. Picking it up at about halfway through the third line, the principle as described in both JT at 50 and A and B at 39 does seem to me to apply to this case. It was rightly not disputed by the defendants that a claim for damages is in principle capable of amounting to a possession with A1P1. And so giving a claim for damages to one cohort in a discriminatory fashion can engage Article 14.
Yes.
But this isn't a claim for damages. This is the possibility of making an application for costs.
Well, it's not, is it? It's the possibility of the realistic possibility of making a claim. You have a realistic possibility of making a claim if you are able to go to the administrative court and get a CFA, but you don't if you come to SIAC.
That's not what the legislation does. The legislation moves claimants from the administrative court and the cost regime there to the...
Yes, but the effect of the legislation is to, I mean, as he put it, sorry, Mr. Armstrong put it, is to remove from one group of people the ability to make a claim. So your comparator for the purposes of working out whether there is you're within the ambit of the convention article is between those two groups, those who can make a claim to the administrative court using a CFA, and those who can't, those who come to SIAC and can't.
I would not accept that the natural effect, the meaning of our interpretation is to exclude applicants from coming to SIAC. It may mean that they cannot be represented under a CFA. People, I think I may be straying a little bit far from the sort of central thrust here, but it's not the direct effect, the direct and necessary effect. We have a system of legal aid in place.
You can get legal aid.
If you're eligible in terms of your means, you can get legal aid. There are any number of tribunals that are cost-free jurisdictions. I don't think there's been any case that says by conferring jurisdiction on a tribunal that is a cost-free jurisdiction, Parliament is preventing people from litigating their rights.
Well, that's because there isn't a comparability, there isn't a comparable cohort, but there is here. I mean, he kept, as I say, Mr. Armstrong kept on putting it as removal, and my Lord quite rightly pointed out that you can't compare yourself with a group who used to exist, but you can compare yourself, theoretically, it seems to me anyway, theoretically, with a group who continue to exist, but have one different characteristic, one different status, and the difference in status is the ability to come, the requirement to come to SIAC because of something the state has done. So, I mean, it is a situation which prima facie does look like discriminatory.
There is certainly a difference between the two cost jurisdictions.
Yes.
I'd accept that. Problem with Article 14 analysis is that sometimes the different stages do tend to sort of leak into each other.
They do, they merge.
They do merge. So I think my short point, and it's not going to improve by my repeating it going around the house. It is not a possession. It is not, in principle, a possession for the purposes of A1P1. If one gets that far.
I thought Mr. Armstrong showed us a case that did talk about costs being a possession.
Well, there are two. we've looked at, and I won't necessarily turn them up now, but I can just tell you what my headline points are on each of them. The first was the Strasbourg decision we've just been looking at, which is the Tarhan
Yes.
case,
32.
tab 32. The point about the Tarhan case was, as my friend quite fairly said, that the effect of the cost order was effectively to dispossess him of the damages that he had got, the financial award that he'd received, been awarded.
Yeah.
In respect of the compulsory purchase. So it wasn't the ability to make an application for costs that was at issue there. It was the making of a costs order that robbed him of his damages. So the link is the damages, and in principle, damages are capable of being in possession with A1P1. So he had been divested of the preponderance of his damages, and that's why it's within the ambit of Article 1, Protocol 1. We're not in the realm of damages at all here. Tarhan was essentially a damages case. The second case is a rather more complex one, and I'm not going to attempt to disentangle it by reference to separate paragraphs of the judgment now, but it's the flood case, which you've got at tab 17. Can I just tell you what I say about flood? So, flood was a case where a number of litigants who were suing the media had entered into conditional fee agreements at the beginning of the litigation. Cost orders were made in their favour. Under the cost regime that was in place, which provided for CFAs. During the course of proceedings, Strasbourg issued a judgment to the effect that enabling people to recover, successful litigants to recover, a success fee against the media in cases where Article 10 was at issue, so freedom of expression, was a breach of the Convention because of the impact it had on Article 10 rights. The media then sought to reverse the cost orders on the basis of the Strasbourg judgment, and the Supreme Court held that it wasn't just the Article 10 rights of the media that were at issue, it was also the A1P1 rights, Article 1, Protocol 1 rights of the individual litigants who had embarked on the litigation with a legitimate expectation that the existing regime would be applied to them. Now, it might be an argument that for people who embarked on litigation under the old regime, they shouldn't be made to transfer across into SIAC, the IGNO sort of scenario. It doesn't mean that the legislation is incompatible with Article 1 and Protocol 1. This is a pretty unique and very different scenario. Those are my points on ambit. Can I then turn to justification? Can I take my skeleton argument on this point in reverse order? It's paragraphs 39 and 40, but I think paragraph 40 logically comes first. And can I apologise because our formatting went slightly awry, so we've got two paragraph 40s. And I'm looking at the paragraph 40 that's on page 62 of the core bundle, beginning as the Supreme Court explained. So there are two different approaches to justification under Article 14. If the difference in treatment is based upon what's called a suspect ground, so things like race or sex, then more is required by way of justification. I think this is uncontroversial. There's no suggestion here that any difference in treatment is based on a suspect ground of that sort. And so, as the Supreme Court has held, in terms of differences in treatment on non-suspect grounds, are wide margins allowed. And the formula used by Strasbourg is the difference manifestly without reasonable foundation.
So I suppose you say Parliament left it up to the Lord Chancellor, and that was a perfectly reasonable thing to do. The fact that the Lord Chancellor hasn't yet legislated is happenstance.
Yes, so I would say that. I also say that having different cost regimes applicable in principle, as between SIAC and the Administrative Court,
because each has their own advantages.
yes. And safeguards.
Particularly if your, but I think you might say particularly if your construction is to be preferred.
Yeah. And on any construction, there are advantages as well as disadvantages to a litigant in SIAC. We've referred to some of them in the course of submissions. So, for example, the assistance of the special advocates, which should not be underplayed. It is really vital and important and a substantial advantage and benefit. The fact that they're not at costs risk themselves.
Yeah.
That point I understand, that they're not at cost risk, but the access to special advocates, I mean, if the legislative choice had been made, as in other contexts it has been, to have closed material procedures in the High Court, then there also you have access to special advocates.
Yes, that's right, they would have, but not in a standard judicial review. It wouldn't be, because you're not dealing with CNP, so moving it into SIAC, there was this entire regime which included special advocates. I mean, of course you can, under the JSA in civil proceedings, have special advocates. And also, it's proceeding being determined before a highly specialist tribunal can be anticipated not to need the same level of assistance and input from counsel or representatives on behalf of the litigants, which is part of the underlying principle, I think, about tribunals generally. They should be accessible to people without the need for expensive representation. So there are different cost regimes in different tribunals, and that's not manifestly without reasonable foundation. Can I just turn my back for a moment? I don't know if you need to address me, you'd be assisted by my addressing you. You need me to address you on Rule 11A and the position if we're wrong about the effect of subsections 3 and 4.
Well, I mean, say what you want.
Okay, I mean, we said the language is absolutely clear on its face 2D4, that if it does confer a cost power, it only confers a cost power where SIAC sets the decision aside, and SIAC doesn't set the decision aside in circumstances where it's withdrawn.
I think the alternative argument Mr. Armstrong advances is that subsection 3 doesn't depend on that wording, and so he says he can come in under the word principles.
Yeah, well, I say he can't. The principles is telling the court how to go about making its decisions. It's not conferring jurisdiction or giving the court powers. It's explaining to the court, legislating about how the court should exercise the powers it has.
And you would emphasise the opening words, that it's in the context of in determining whether to set aside
Yes,
the decision.
yes, I would, absolutely. That's also addressed in our skeleton argument. Tab 7. Round 5, pages 62 to 63.
Which paragraph?
It's the second paragraph, 41, it's page 62 to 63. And we've referred to L.O. Jordan, which you've got at tab 13 of the authorities bundle.
Yeah.
And you'll see at paragraph 11 on page 207, Rule 11A is set out. And the question arose there in the context of appeal rights, because the appellants wanted to appeal, and they could only appeal if there'd been a final determination. And at paragraphs 15 to 16, the court rejected the submission that has made a final determination. I'm picking it up 4 lines from the end of paragraph 15. Submission was, has made a final determination of an appeal, must be construed so as to embrace, has made its last substantive decision. No warrant for that. Quite simply, we lack jurisdiction. Mr. Justice Jay approached the matter by saying SIAC is called upon to make a judicial decision when notified by the respondent that the decision under review has been withdrawn. It's quite clear, we'd say, from the language of Rule 11A that it's not a judicial decision. You've got it at tab 3. And it couldn't, in our submission, be much clearer. It's 11A3, 2 and 3. So an appeal shall be treated, or application for review, shall be treated as withdrawn if the Secretary of State notifies the Commission that the decision to which the appeal or application for review relates has been withdrawn. So shall be treated, not may be treated. And then at 3, if an application for review is withdrawn or treated as withdrawn, the Commission must serve on the parties and on any special advocate a notice that the appeal or application for review has been recorded as having been withdrawn. The Commission's not dismissing it, it's not setting the decision aside, not exercising any judgment, simply performing an essentially administrative act of notifying the parties that the application is treated as having been withdrawn.
In the admin court, it's commonplace that a decision can't just be withdrawn by the executive. The parties can agree that, for example, a decision is to be quashed,
Yes.
or some other consensual outcome is agreed upon. But nevertheless, is this right, that it's common practice for the administrative court to make an order? It's not bound by what the parties have agreed, but very often it will endorse the consent order. Now, SIAC, as I understand Mr. Justice Jay's judgment, he appears to have drawn an analogy with that kind of scenario.
Yes.
But you say that's not an analogous situation.
It's not analogous at all. I'm not aware of any provision that would require the administrative court in that way must treat it as, or shall treat it as withdrawn, must notify the parties. Parties, as you say, submit a consent order, but that's subject to approval by the court, and the order is made.
And it's usually supported by reasons.
It is.
Because there's a public interest. You can't just have people stitching up things by private agreement. The public very often needs to know that a public authority is acting properly in agreeing to have its decision quashed.
Yes, I would absolutely agree with that. I'm told that McCaffrey is going further, and it's listed before this court in October. So
I think that may be on a contingent basis, that either it's going to be an appeal, or if an appeal is not available, it will have to be by way of judicial review. Because, of course, this court can reconstitute itself if necessary as a divisional court. I'm just guessing, but I think that must be.
we could try and find out more.
By the way, it's listed before this court.
Well, it's an encouragement to us to get our judgments out.
Or not.
Or not.
Then, unless there was anything on the grounds that you wanted me to address you on further, can I just mention one point of fact, because it seemed to trouble my lords when the point was made by Mr. Armstrong. He said that FGF had to withdraw his appeal because the Secretary of State wouldn't agree, essentially not to pursue him for costs, couldn't proceed with his judicial review, or couldn't proceed to defend the judicial review. That is with respect to rather partial analysis. You've got the correspondence at the time in the supplementary bundle, it's at tab 5. And if I could just ask you in your own time, I'm not going to take you through it now, but to consider the letters from the Government Legal Department on the 24th of April and the 1st of May 2024, pages 129 and 134 to 135, and you'll see that essentially the Secretary of State was asking, in accordance with the civil procedure rules, for evidence as to FGF's means. And you see that at page 129 of the bundle by the lower hole punch. We note that the CPR, I'm picking it up halfway through the line, we note that the CPR provides that an application for a cost capping order is required to be supported by evidence, including as to the applicant's means. We're aware your client's income and capital are such that he's not eligible for legal aid. You've provided very limited information beyond that, other than the assertion in correspondence that he is of low income and resources. In the absence of such information, we propose a starting point for discussion, a reciprocal cost cap in the sum of £3,500. And then again, 1st of May, still no evidence as to his means, and the offer of a £3,500 reciprocal cost cap is repeated. So, Secretary of State did try very hard to resolve matters so that FGF could pursue the litigation himself, but in the absence of evidence as to his finances, which says entirely reasonable of the Secretary of State to make the offer she did.
Well, they offered to be liable for £1.
Beg your pardon, my lord?
They offered to be liable for £1.
Yes.
And you said that wasn't acceptable.
No. And it may be that if we'd had evidence of means, the negotiations would have gone further. But in the event, as it happened, H7 and H15, who are both legally aided, were able to step forward and pick up the mantle, so to speak.
Right, okay.
Could I just very briefly turn my back? Thank you, my lord.
Thank you very much. Yes, Mr. Armstrong.
Well, thank you. I'll deal with these in the order in which they arose. Starting with the domestic construction point, I'll take that very briefly. I simply adopt in relation to the construction of section 2D4 my Lord Justice Voss's starting point, which is that all of the arguments that my learned friend advances do too much violence to the clear words of the Act. One should not be, I'd say that this is an orthodox approach to statutory construction. My Lord Justice Voss says this is weird, I think was the word that was used. I say it's impermissible. The orthodox approach is you should not be digging around in section 5 and section 6A looking for different versions of what order means, and this is a different kind of, it means some orders but not other orders. You are supposed to be able to rely on the plain words of the section, including, and I make the forensic point again, 4 experienced judges who are used to reading this legislation, are familiar with this legislation, familiar with the context, and familiar with the legislative history. The clear wording is the clear wording. It means
what if, what's said against you is that, and I think it does take a bit of, it's one of those points that is difficult to see initially, is yes, there was clear wording, and yes, in 99% of cases you give effect to clear wording. But when you stand back from this and you look at every other piece of context in this legislation, it is, I put it this way, not Ms. Giovanetti, she doesn't agree with it, but I put it this way. It's perfectly obvious that the legislation is making a mistake. And it's actually obvious on the face of the legislation, because Section 6 was there before. Section 6 provides for a cost regime, a procedural regime to be enacted. Section 2D, 3 and 4 is all about making judicial review orders. You've got a perfectly good piece of legislation, Section 31, which talks about that and what they are. And it's 6A makes it the same regime as the cost as the appeals. The appeals is no costs, as we know from C7, and the whole thing is obviously doesn't say what it means. And order and relief, yes, you can get a little way with that, but order actually is probably referring to whatever it is, 31.5. And so you have to do some violence to the language in order to achieve what Parliament really intended. And that may seem counterintuitive, but there isn't a single pointer in your direction except the clear words. That's what's said against you.
The difficulty with that, my lord, is this. I've taken the opportunity, and we can provide it, to have a look at Benyon on mistakes.
Good.
And basically there are, in order to correct a drafting error, and the language is, the court must be abundantly sure of the following matters, and there are 3.
Abundantly sure. You're going to let us have this document.
I will. Yes. All that. The intended, this is section 15.1 of Benyon, the intended purpose of the provision in question.
You have to know what the mistake is.
You have to know what the mistake is, and I say it's a different mistake. The mistake here is not treating it like judicial review. 2, that the drafter and the legislature inadvertently failed to give effect to that purpose in the provision. Again, you need to know what the purpose was, and all of the discussion is saying we're treating this like judicial review, except we're adding a closed material procedure. All of that discussion is about that. See what Lord Taylor says. We're bringing these in. You're all moving these, and you see the other language in my skeleton argument. They're all hearing judicial reviews. I mean,
the problem with that argument is that this provision you actually rely on is not treating it like judicial review. The problem you rely on is doing something weird, to use my word again, doing something actually almost unheard of. So the argument that they're just transposing the judicial review regime in doesn't run, because what they're actually doing is transferring the judicial review regime in subject to section 6. That is definitely what they're doing. They envisage that even though the Lord Chancellor hasn't made rules, he could make rules for costs and procedural matters that matched judicial review. But the 2D4 is just an error, seemingly. I mean, it's just a too broad a provision to do something quite modest.
Well, my answer to that is, it may be doing something a little bit weird, but it is more weird, to use that word, to strip out costs.
So they're not stripping out costs, they're leaving it to the LC.
Well, nobody seems to have told the Lord Chancellor that for 13 years, and nothing has been done. And that leaves my remedy, and this is an Article 14 point I'll come back to in a moment. Maybe I'll deal with it now. When I get into Article 14 and the Section 3 duty, I have no other remedy. I come to you and say, use Section 3 to construe this. If I can't get there domestically, I say, use this more muscular duty, Section 3, see Guide and Menosa, you've got it in the bundle, and you've got it in the skeleton argument. Use that to produce the result, because I am asking you to act to correct what would otherwise be an incompatibility, a breach of my rights, which is I've now been stripped of this. I can't sue, as has been suggested, the Lord Chancellor for this. I can't bring about that remedy. Yeah. And there's at least 2 reasons why.
That's one thing you can't do.
Well, there's at least 2 reasons why I can't do that. One is that's not going to produce me what I want, which is access to a system that might give me citizenship. I could just sue for damages. I'm not going to get that from an HRA claim. But also Section 6.6 of the Human Rights Act excludes from the list of actionable public authority acts the failure to bring forward legislation.
Yeah.
So the only way I can fix this is via Section 3 reading. So that's my difficulty in relation to that. Next point on McCaffrey. Can I just say, and I adopt again my Lord Justice Foster's point about this. It's a case against me.
He's the master of the rolls, Mr. Armstrong. Give him some credit.
Yes, I'm
I used to be Lord Justice, boss.
Yeah.
I am very sorry, and you're right to pick me up on that. But my lord, that is it's a different context because of the way Section 67 works, and I've already taken you to that, which is it has specifically focused on those acts which are substantively different. It's different here. Section 2D4 doesn't do the same exercise. Can I also, and I hope I haven't misunderstood this, and no doubt my Lord Justice Singh will say this, if I got this wrong, but one of the things about legal certainty which was referred to was the IPT was concerned that there will be a lack of legal certainty if you created this unusual jurisdiction in the IPT, a new jurisdiction for cost in the IPT. What are the principles on which it would be exercised? In this context, there is no doubt about the principles that would be exercised because they are the M. and Croydon principles that have been applied without any difficulty. So I don't, again, that's another distinguishing feature of McCaffrey. The legal principles are clear. And my learned friend took you to Rule 10 of the Tribunal Rules and referred you to both A and D. I remind you that we are being treated significantly less favourably than a judicial review in the Administrative Court, M. and Croydon, a judicial review in the Upper Tribunal, again, M. and Croydon, or a tribunal appeal in the Upper Tribunal or the First Tier Tribunal, which has an unreasonable conduct provision. This is a very odd thing to have done to us in the context where there is no reference to it, no explanation for it, no thought given to it, nothing other than, and I do say again, when one reads carefully the explanatory notes, Hansard, the rest of it, they appear to think you're just transferring in a judicial review. It was said that, but there are advantages to being in this. You don't pay for special advocates. The problem here, the fundamental difference in treatment that is the concern and gives rise to the concern, it's not about, okay, we don't have to pay for special advocates. Bear in mind, I mean, H7 and H15 had special advocates in the judicial reviews that they previously advanced. They are available in the Administrative Court. They had them in those things. That's not the problem. You don't get to the special advocates if you don't have solicitors to bring these cases, if you don't have funding arrangements that work. That's the problem, and you don't cure that access problem by bringing in a special advocate and not say, oh, well, you'd have to pay for that bit. You don't get there. And I remind you again, I made reference to the distinction between tribunals generally, and they're being generally cheap and informal, and they're supposed to be sort of quick and easy. I know some of them are not. But I make that informally, that point, that some of them are not. But bear in mind what these cases are like. These are not like first-tier tribunal cases which are listed for half a day. These are days and days of, you've got silks on either side, they run for months of preliminary hearings, you've got determinations engulf into private for long periods of time. These are heavy cases. You need to have solid economic bases before you can embark on one of them. So those are my submissions on those. Moving into Article 14, I've mentioned, as I've said, I do maintain Article 8. Can I just, I've referred in the skeleton argument to Johnson because it's part of the identity, having your citizenship. Can I just also mention on that, just for completeness, it's not just Johnson on that point, it's also the decision on statutory interpretation my learned friend relies on is the decision of O. Can I just refer you to, just for your note, paragraph 26 at page A, authorities 548, talking about the importance of identity of citizenship. So that's another. That's why we get in on Article 8. But as I say, because I'm representing H7, H15. I focus on A1, P1, but it's just a focus. Ambit, costs as a possession. Two ways of doing this. FGF himself now has a liability that he wouldn't otherwise have. as a result of this action. He is now liable to his solicitors for those costs. Okay? Straight point. But there is also the positive modality point. And I do rely on AA, the special educational needs case. Very important, and I adopt gratefully Mr. Justice Singh's analysis. But it's not a controversial analysis. It reflects what my Lord Justice Singh and I were discussing about positive modality, and it reflects Lord Justice Hickenbottom's reasoning in the JCWI case. What that is about, it doesn't matter that that was a claim for damages and this is a claim for costs. Doesn't matter. That's just a distinction without a difference. Strasbourg is concerned with practical realities, not distinctions of that kind. What a positive modality means is if you create a scheme where I can get something of value, and that is here a challenge, which is part of, I get costs in order to get me there, I've got an economic arrangement that allows me to get there, but then you deny it in an unjustifiably discriminatory way for one particular cohort, then that is a positive modality discrimination, in the same way as it was in AA. Like you've seen Tarhan, you've seen flood. These kind of arrangements are capable of being a possession in the same way as anything else is. And just for your note, you might want to look also at the case of Diallo, which is in the authorities bundle. That is a claim by lawyers for costs. So that is a claim to a possession. And the possession happened to be costs. That is, if you look, that starts at, and I'm afraid there's an unofficial translation of this, but it's, if you look at page 818 of the authorities bundle, that talks also about the importance of those particular kinds of claims because of their connection to access to justice and the rule of law. So we say, so far as ambit is concerned, it's a straightforward analysis. Are you losing something you had, or is somebody else being given a claim to something of value that you are not being given on an unjustifiably discriminatory basis? And that's where we are. Not having these costs arrangements, I emphasise again, significantly hinder access, and it is getting worse out there. I mean, certainly in my time at the bar, it gets worse and worse because, for unsurprising reasons, you see that legal aid rates remain as they were. I think it was in 1996 was the quote that we had in Mr. Carey's witness statement. And if you don't have inter partes costs and the cross subsidy that allows claimant lawyers and applicant lawyers to do that, then you can't get that cross subsidy and you can't run conditional fees or discounted conditional fees, then there is going to be a problem. And that's why I think, and my Lord will know this better than I do, but that's why you don't get lots of those cases in the IPT. That's why they tend to be NGO cases in the IPT rather than lots of cases brought on behalf of individuals, because they don't have the cost rule, because you can't run things in the same way. And
well,
so
I think we need to be careful here. There could be many reasons. A lot of what the IPT does is not done in the public domain. So there are lots of. I need to be careful what I say. There are lots of cases that people don't know about.
all right. Well, that's. But as I said, all I need for these purposes is the cases that I'm saying. This court has repeatedly recognised in the context of Devon Croydon type orders that inter partes costs are important. They are an important part of the way the justice system works. So they are connected to the rule of law. And that situation is, as fees remain the same and inflation goes up, that situation is becoming more pronounced, not less. On justification, what we are saying here is what you are looking for from the Secretary of State, if I've established discrimination, is an explanation for why that is necessarily connected to a legitimate purpose, such that it justifies the impact that this has. And that is a significant impact. That is an access to justice impact that operates in a weird and partial way, that means that the tribunals can't control, including here unreasonable conduct, which might include an unreasonable withdrawal. All of the things that the courts usually use costs to do. All of you've got an access to justice problem. You can't regulate the proceedings in the same way. Has all these sorts of impact. It potentially allows arbitrary results like abuse. what's the justification for that? And there isn't anything that says what the justification for that is. And references to, well, you get special advocates for free, he gets nowhere near justifying that kind of impact, because, as I say, you wouldn't get there in the first place. If you don't have solicitors who are able to act and have funding arrangements of the kind that the Access to Justice Act 1999 and all of the other things since then, now the Legal Aid Sentencing and Punishment of Offenders Act, Parliament has legislated to give things like CFAs to fill the gap as legal aid has withdrawn from the field, the market steps in via these arrangements, and this is being pulled back by this. So that's where I say on Article 14. And finally, I just say on Rule 11A, I want to just mention Article 14 in that context as well. I say that Rule 11A needs to be read domestically in order to give effect to, that may be a mistake. Allowing Rule 11A to remove what would otherwise be a costs power is an unintentional mistake to which Parliament's attention was not drawn. And domestically, you could fix it that way. But you can definitely fix it that way via Article 14, because if Article 14 applies in the way that I say it does, the costs power needs to be present, and it cannot be removed by the Secretary of State seeing which way the wind blows or whatever else is going on, as Mr. Justice Jay does, is suddenly pulling it and saying, well, now there's no set aside and I can't do anything about it. If I need a costs power, it needs to be a cost power that applies in the same way as it applies in the administrative court, because that's the comparable cohort. So I'm just going to, unless I can assist.
Well, can I just ask what your answer is to Ms. Giavanetti's knockout point on Section 5? Basically, she says this whole Article 14 argument is misconceived because of Section 3 of the Human Rights Act, which says that primary legislation and subordinate legislation must be read and given effect in a way which is compatible with convention rights, and the provisions in the primary legislation is indeed compatible with convention rights, because the power has been given to the Lord Chancellor to make a cost provision which would be compatible. He just hasn't done it yet.
My answer is the answer that I think I've already given,
Yes.
which is that doesn't help me if the Lord Chancellor hasn't done it. I need that. The only remedy I have is to come to this court and say I need the cost. I need it to be read compatibly now, because there is nothing I can do to get it from the Lord Chancellor. The only equivalence that I can get is I needed to have, too late for FGF now, I needed to have access to a mechanism that was capable of giving me access to justice, and that justice was the opportunity to overturn.
But you're asking us to read the legislation compatibly. What relief are you seeking?
I am
Article
seeking
14.
the restoration of my costs order, fundamentally, for FGF. I mean, I'm not representing FGF now, but that is what would happen.
You're not asking for a declaration of incompatibility.
No, I'm asking.
Okay, so the only thing you're relying on in the Human Rights Act in this context, Section 3.
True.
Right. The trouble is the logical foundation before Section 3 gets off the ground is that you've established an incompatibility
Yes.
between the primary legislation and a convention right. And what my Lord has put to you is, what's your answer to what Miss Giovanetti says is her knockout blow, which is that you can't show an incompatibility in the primary legislation, precisely because it doesn't stop you getting costs, it doesn't exclude you from having that option or that possibility, but what it does do is confer power on the Lord Chancellor to make rules setting up a costs regime, so that she says there's nothing incompatible in the primary legislation.
I have a live incompatibility, that it remains uncorrected and uncorrectable. The incompatibility with my rights is that I am left without the costs order. And so I say that in order to do the Section 3 exercise, having regard to the fact that I can't get it anywhere else, this is the only remedy I can get. The only way I can get it, the only way of fixing it, is to read the primary legislation the way I say it can be read, including domestic.
Yes, but I mean, it's not a cause of action. Where's what? I mean, where is your notice of appeal?
Well, my grounds would be.
Yeah. Well, your notice of appeal, actually. Appellant's notice.
First document in the Court of London.
So the appellants seek to appeal the decision of the High Court, allowing the Secretary of State's claim for judicial review, quashing the decision of the defendant, dated 2024, the defendant being the Commission, and providing declaratory relief, blah, seek to appeal the decision of the court below, requiring the interested parties to pay the claimant's reasonable costs of the claim. The order, decision of the defendant to award costs to the first interested party is quashed. And the defendant seek to appeal the decision of the High Court, allowing the claim for judicial review, paragraph 1, quashing the decision of the defendant. So you want to
Restore the costs order.
restore
which is
the
now
costs
being
order,
quashed.
and you do that.
And also reverse the costs order below against us.
But you can only do that on the basis. How do you do that via the Article 14 route?
I say that
What is the legal route?
the legal route is Mr. Justice Jay was right for the reasons he gave, slightly adjusted as we've set out at various points, and he was also right for the additional reason that Article 14 requires the reading that he gave.
No, sorry, I'm not being clear. Let's assume that the proper construction of the statute is as Ms. Giovanetti says, right? Mm-hmm. Not my or even my interim suggestion earlier today. One of those two, but not that that you can simply disregard the first part of 2D4.
Yeah.
Okay. In that situation, there was no right to award, no power to award costs. So what is your legal route via Article 14 to that costs order for FGF?
Because I say that the reading of those, so I say that section does in fact give the power to award costs. Firstly, domestically, if I lose on that. Secondly, with the more muscular article, Section 3 duty. Because, and we can go to Guy and Mendoza, but there is no fun. Guy and Mendoza is the case in we refer to, but we haven't gone to. Shall I go to it?
Well, I'm just asking you the legal route. If you know,
I am saying the divisional court was wrong in its construction. Even if I lose on the first point, the domestic construction, it was wrong on the second point, which is even if you can't get there domestically, you can get there without doing because you have a more muscular construction route.
I mean, I'm afraid, I'm sorry.
And that would say either principles or any order includes a costs order, because if you don't do that, the outcome is an incompatibility with my rights, which is I have been treated unjustifiably discriminatory.
So how do we give effect to the primary and subordinate legislation in this case so as to make it compatible with FGF's convention rights?
By construing sections either 2D4, 2D3, and or disapplying the effect of Rule 11A to ensure that I am given a cost power in the same, I'm given a costs order as if I was in the administrative court.
So as to allow cost orders at large?
To allow, in this case, the costs order that I've already got from the tribunal, from the commission. Because that's the only way of avoiding what would otherwise be.
There's a bit of woolly thinking here. I need to know how we are supposed to construe sections 2D4 or 2D3 so as to allow the costs order that you got below to be made in the event that the domestic construction is as I've said. So in other words, you've got a clear statute, and the domestic construction is either the one I advocated for this morning or the one Ms. Giovanetti advocated for this afternoon. Those two possibilities, but not the one you want. Now, how do we now, with that domestic construction, apply section 3 so as to read and give effect to the convention rights of your client?
Because you would say in those circumstances that we can't get there on a domestic basis. So
no, my question is, how do we read and give effect within the words of section 3? The only way you can go there is through section 3. There is no other route.
To section, yes.
Section 3, 1 of the Human Rights Act. Now, I'm holding your feet to the fire, Mr. Armstrong.
I can see, yes.
Because I need to know what you're asking me to do.
I'm asking you to read any order.
To read and give effect to 2D3 and 2D4.
As including an order.
So as to say what? Not so as to include some cost order that you want, but so as to say what?
It includes the power on M. Croydon principles to make a to make an order in favour of the applicant, an order for costs in favour of the applicant, because
where the decision has either been set aside or withdrawn.
Yes, well, yes. Because otherwise.
But that doesn't help anybody else coming to court to know what this section means, just to know that your client gets a cost order. What you have to say is how normally in these reading down cases you say how it should be read. So you say go back to 2D4 and 2D3, and let's do that for a moment. Have it on the screen. And we see 2D4 and 2D3, and we say that 2D3 must, or 2D4 is really the key one.
Yeah.
You delete if the Commission decides that the decision should be set aside, and simply say the Commission may make such order or give such relief as may be made or given in judicial review proceedings, including as to costs.
I might struggle to. So the Guidon Mendoza requirement is you can be pretty powerful in your construction.
Yes.
But you can't alter a fundamental feature of the legislation.
No.
That's what it says. You can change the meaning, but you can't alter a fundamental feature. I might be struggling to say if the Commission decides that the decision should be set aside is not a fundamental feature of the legislation. But I simply say, if the reading that I seek this stage is if the Commission decides that the decision should be set aside, it may make any such order or give any such relief as may be made or given in judicial review proceedings. For the avoidance of doubt, this includes an order for costs. And then I probably need the additional read that 11A doesn't prevent that.
And 11A is not primary legislation.
No. So if 11A required a different reading, it would just be ultra vires that provision, as now read.
Okay. Well, you've finished now, right?
I have, yes.
I'm going to ask Miss Giovanetti if she wants to make any comment on the point that I asked you, because I didn't ask her for her submissions on that.
Last point about how you would read.
About what Section 3 allows you to do and what it doesn't allow you to do.
Well, I agree with what Mr. Armstrong says. It allows you to interpret legislation more flexibly.
Yeah?
But not to change a fundamental feature of the legislation
And
or
do you
something
say
that's
this
central
would,
to it.
yeah, do you say,
We say this is central. It's a
you
short
s-
provision.
You
and-
say this would change the...
yes.
Well, if that's right, then we may have to consider making a declaration of incompatibility. If otherwise the argument has got that far and the court is on the verge of using Section 3 but can't do it for the reason you just mentioned, that then
There's no claim for never has been for a declaration of incompatibility. So we've not come here armed to argue about a declaration of incompatibility. I think we would want an opportunity to address you about relief if that was to be advanced. But our fundamental point remains my first point, which is that the effect of the legislation is not to prevent or preclude a cost regime in SIAC. It's simply leaving it to the Lord Chancellor, and that can't conceivably be incompatible. So we come full circle.
I'm back full circle. Thank you. Mr. Armstrong, you're entitled to the last word.
My Lord, unless I can assist you further,
That is the
my
last.
submission.
Thank you very much. Okay, well, thank you both for an interesting argument in an interesting and potentially important case. So we much appreciate the help we've received from counsel, including your juniors and solicitors. And since I was rather rude last week about a set of bundles, let me say how good the bundles have been today, and thank you for your second bundle served very promptly at lunchtime. We will hand down our judgments in the usual way at some stage. I'm afraid I can't guarantee when, but it could be after the vacation. But when we do, we will tell you we're going to do so, and we only want typographical and we only want corrections. We don't want re-argument, and you may use the embargoed judgment to agree an order as to costs, but very likely we'll give you a short time before the hand down just for corrections, and then you may have another 7 days in order to agree costs and any consequential directions that arise, so you don't have to run around too hectically in the 48 hours we'll probably give you to do the corrections. Thank you very
I
much.
apologise for the fact that my voice has been giving up progressively over the course of the day.
It's all right, everybody's been speaking too quietly today, so we're all in the same boat. Thank you very much.
Thank you.
All right, able.